Discussion, all in favor?
Aye.
All right, I need a motion to appoint Kent to oversee the meeting.
So moved.
Step out.
Second.
Okay, discussion, all in favor?
Aye.
Aye.
Okay, do we need, I guess we'll kind of do that shortly, huh? Okay, so we're on item number 6. So I think first thing we need to do is we need to get a motion for them get to waive their rights to be here in the second judicial district.
Motion.
Second. No,
They need to
we
tell
need to
us.
call them forward.
They need to tell us.
Yeah, to ask them to waive their rights in the second judicial district to be heard in the first judicial district. Because they have properties in the second judicial district too.
So we recognize representatives from AT&T Mobility LLC to discuss 2025 property tax assessment protest for assets located in the first and second judicial districts.
First, ask him, state that he's waiving his right.
We just need you to state that.
Oh, yeah, you want to state?
First off, you need to state your name and address for the record.
So I'm William Gingrey with AT&T Property Tax out of Atlanta.
Can you spell that last name?
Gingrey.
The first question they're asking you, do y'all waive your right to be heard in the second judicial district, since we're here in the first judicial district having this hearing today?
That's fine, yeah. All right, good morning, Board of Supervisors. I want to thank y'all for the opportunity to speak before you today. As I said, my name is William Gingrey. I'm a lead tax manager with the Property Tax Bureau out of Atlanta with AT&T. And with me today is our outside legal counsel, Stacy Thomas with Baker Donaldson. And introductions via Zoom. We've got our in-house counsel, Ben Gardner, with AT&T on the line, and we've got my colleague, Richard Sullivan, in property tax, and I believe we have, also have Sterling Kidd. Sterling's not joining, okay, so that's it. We've got those two on Zoom. As you may recall, AT&T has objected to the proposed values in prior years, and based on my comments to follow, you'll see that the reasons for those objections have not changed. And I brought with me there, I've sent over actually, hope that y'all have the binders that I'll refer to throughout my comments, which hopefully is going to help us along. So let me start off with a quick background here. And by letter to the Harrison County Board of Supervisors, dated on July 29th, 2025, AT&T Mobility filed an objection to 2025 assessments proposed for its taxable cell site equipment for 2025. And that is included in the binder as Exhibit 1. AT&T submits the following information in support of the 2025 objection. In compliance with Mississippi statutes and property tax reporting guidelines, AT&T filed fully executed and certified copies of Form 73033 MSTC Rev 01 for each separate and unique location and/or Harrison County Assessor's Business Personal Property Account Number, timely for the tax year 2025. Additionally, AT&T has filed a complete listing of all equipment that it contends qualifies for the Mississippi Broadband ad valorem tax exemption, as defined by Mississippi Code annotated 57877. Along with a certified sworn description of the broadband exemption equipment as required by Mississippi House Bill 1644, signed into law by Governor Reeves on March 28, 2025. Both the renditions for taxable personal property and the certified sworn description of qualifying broadband exemption property were filed according to AT&T's books and records for original year new and original cost new, in compliance with Mississippi statutes and guidelines for reporting business personal property. Information obtained from the Harrison County Tax Assessor indicated that the assessor's office was denying the broadband exemption for all equipment reported by AT&T as exempt, and rejecting the appraisal method mandated by Mississippi statute in favor of a highly speculative and unreliable approach where a third-party consultant attempts to divine the items of equipment present in the county through reverse engineering without the benefit of a thorough inspection or inventory, and then attempts to obtain cost information for the hypothetical equipment from sources other than AT&T vendors. So there's the rejections are twofold: denial of the broadband exemption and the fair market value estimate of taxable personal property. And now allow me to get into AT&T's response to further the
Before you
objections.
go to that, can I ask a question? Where is the oath? It's supposed to be under oath. I don't see anything contained in the notebook that's signed under oath and what tax assessor so.
So the oath, the sworn statement was included as part of the rendition. I actually have here a copy of that.
I see that, that's what I was asking.
So there's 10.
Go ahead, I'm sorry.
Can we keep going?
Yeah, go ahead.
Okay. AT&T contends that all the equipment listed by original year new and original cost new on the listing of broadband exemption equipment, which is included in the binder as Exhibit 4, meets or exceeds the specific requirements set forth by Mississippi Code annotated 57877. Equipment used in the deployment of broadband technologies by a telecommunications enterprise as defined in section 5773-2114 that is placed in service after June 30th, 2003 and before July 1st, 2025 shall be exempt from ad valorem taxation for a period of 10 years after the date such equipment is placed in service. For purposes of this section, equipment used in the deployment of broadband technologies means any equipment capable of being used for or in connection with the transmission of information at a rate prior to taking into account the effects of any signal degradation that is not less than 384 kilobits per second in at least one direction, including but not limited to asynchronous transfer mode switches, digital subscriber line access multiplexers, routers, servers, multiplexers, fiber optics, and related equipment. As stated earlier, Mississippi House Bill 1644, signed into law by Governor Reeves, March 28, 2025, amended Mississippi Code 57877, which is the section that addresses the ad valorem broadband exemption section 3, states, equipment used in the deployment of mobile broadband technologies by a telecommunications enterprise that is placed in service after June 30, 2025, before July 1st, 2030, that is capable of transmission at an average speed not less than 35 megabits per second downlink and 3 megabits per second uplink, shall be exempt from ad valorem taxation for a period of 5 years after the date such equipment is placed in service. Section 4 states that a taxpayer seeking an exemption for equipment under this section shall submit a certified sworn description of such equipment, including transmission speeds, to the tax assessor of the county in which such equipment is located, on or before April 1st of the first assessment year in which the exemption is being applied. Mississippi Code 5773-2114 states, as used in this section, the term telecommunications enterprises means entities engaged in the creation, display, management, storage, processing, transmission, or distribution of, for compensation of images, text, voice, video, or data by wire or wireless means, or entities engaged in the construction, design, development, manufacture, maintenance, or distribution for compensation of devices, products, software, or structure used in the above activities. The Harrison County Assessor's Office has provided no meaningful reason as to why Mississippi law regarding the broadband exemption should not apply in Harrison County.
23rd Avenue towards 17th.
AT&T contends that the broadband exemption should apply to all its equipment reported as exempt, as it is integral to the process of broadband services via cell site wireless means. Number 2, Mississippi law requires appraisal based on original acquisition cost and original year new. AT&T contends that it has complied with Mississippi statutory and guideline requirements regarding the original year new and original cost new for taxable business personal property in Harrison County, included in the binder here in Exhibit 3. With regard to the consultant methodology, based on prior experience in other jurisdictions, AT&T expects that the proposed 2025 assessments are based on highly speculative and unreliable attempts at valuation. Mississippi law is clear that true value is to be determined based on original cost new, original year new, and the application of factors provided by the Mississippi Department of Revenue. AT&T provided true and correct information on original cost new and original year new from its books and records. In contrast, proposed assessments are based on hypothetical equipment and imagined by a contractor to be present, and on cost assumptions based on quotes or other data not obtained from AT&T vendors. The Mississippi Supreme Court within the recent past upheld a court's exclusion of testimony of a taxpayer's appraisal expert because his report was based on factors other than original cost new, and original year new. The court said that the approach advocated for by AT&T in this case is the sole and exclusive allowable approach for appraisal of this type of property. It should be noted that in this case, the taxpayer's expert was a highly experienced and credentialed appraisal expert, expressing an opinion based on accepted appraisal standards. In contrast, to the best of AT&T's knowledge, the county's consultant has no appraisal credentials, is not bound to apply any appraisal standards, and is not qualified to advise with regard to applicable Mississippi statutory requirements. So, in summary and conclusion, AT&T contends that the true value of its taxable business personal property in Harrison County, Mississippi for personal property accounts included in its 2025 objection filing should be no more than $3,990,093, and that is Exhibit 2 in your file. So those are our objections as stated, and happy to answer any questions.
I did have a question, can I ask?
Sure.
Yes, sir.
The oath, I'm just reading what you provided, is that the only oath that AT&T provided in support of its rendition? What you provided?
I believe that's correct.
You agree with me that section 2735-23 subsection 5 states, each list shall be verified by oath, which the assessor or his deputy is authorized or required to administer to each person as follows. Quote, you do solemnly swear or affirm that the list of property you have made for the purpose of taxation is true and correct, is a just, true, and true account of all properties you are required to render subject to taxation in your own right or that of any other person for whom you ought to give in taxable property, and that each statement of facts is true and correct as stated, and that no property subject to taxation has been omitted, and all property has been listed at its true value, so help you God. You familiar with that quote out of the statute of what the oath is supposed to state?
I can if I may, as Mr. Giger said, I'm Stacy Thomas, I'm with the Jackson office of Baker Donaldson. I can pass this around, but if you look at the property tax rendition form, the last comment before the taxpayer's signature is an oath that states on its face that it is the oath required by the section that you read, and it is signed by the same person who signed the oath.
You're talking about the form?
Yes, sir.
You agree that that form does not follow the quote out of the statute?
That form is adopted by the Mississippi Department of Revenue, and another statute says taxpayers shall use the form adopted by the Department of
That
Revenue.
wasn't my question. You agree that statement does not comply with the statute that I just read as a quote?
It says it's the oath required by that statute.
I understand what they say. I'm saying that that oath attached to that rendition does not state what the statute says it shall state.
I agree with you that it is not as detailed as what the statute says. I do not agree that it doesn't satisfy the statute.
There was wasn't
I
arguing
know,
about
I
that.
understand.
But you agree with me that the one that he provided us here, that passed out a minute ago, the board members got, does not, state what the statute says either.
That affidavit goes to the law that was passed on March 28th, and it says the first year that you claim an exemption, you have to provide a sworn statement describing the property, and that was the purpose of that.
This does not follow the quote of this statute either. Do you agree with that?
Yes, sir, I would agree with that.
And was CST allowed to inspect y'all's towers? Yes or no? Were they allowed to go in and inspect actually what was in the towers?
They did not inspect the towers, to my knowledge.
Were they allowed to?
They never asked it.
Would you have allowed them to?
No.
Wouldn't be good to ask if you'd already been told no, would it?
You can't say no until we're asked.
Well, it's kind of hard for them, you come in here and you say that you've rendered a true and correct list of the cost, and they had to do estimates, but yet they weren't allowed to go in and look at, as a representative of the tax assessor, they were not allowed to go in and inspect the actual equipment to determine what was there and what the value of it was. Do you agree with that?
Well, I mean, you have to understand,
Where they, well, first answer the question, and then you can explain it all you want, but you agree that they, without going into the towers and looking at what was actually there, which you agree the tax assessor has that right? to
Sure,
inspect
yes,
the property. And
As an agent.
do you, is it the position of AT&T that the tax assessor cannot hire somebody to assist her in reviewing that equipment?
I don't know about whether or not she's allowed to hire anyone. We certainly don't object to her hiring someone, but we do object to taking them onto our sites.
As an agent, aren't they an agent of the county?
The agent of
And
the
as
tax
an
assessor.
agent of the county, wouldn't they basically be as the assessor herself,
That's correct.
having the right? That's our contention.
I have a question. So 2 years ago, I built a new home, and the tax assessor's office, Kevin Lee, come out, measured everything. Once my home was complete, City of Biloxi turned in that they did the whatever, CO. I can't tell that guy that he can't not come and measure my house. I mean, I can't just call and say, hey, this is how much I'm gonna be taxed on, or this is the size of my house, this is how much you're gonna tax me.
No.
How do they have the right to not allow an agent of the county to verify?
I don't think they can.
Okay.
In fact, a year or two ago, somebody showed up at my office. My brother called me, I don't know where I was. There's some guy here that wants to go through our office from the county, wanting to inspect all of our stuff. Can they do that? And I said, yeah, he has a right to do that, so let him in. Otherwise, he's gonna do an estimate of what is in there, which is all they can do when you're trying to do an assessment if the taxpayer will not allow you in to inspect the property. So, I'm just trying to establish in this case, Paula had a county contract, it was a CST, I'm sorry. CTS. CTS to help assist in evaluating these towers, but yet CTS was not allowed to go into the towers to inspect them to see what the equipment was there.
I am curious that if the CTS agent that we had was accompanied by an employee of the assessor's office, would you allow that, then them to access the equipment to review it?
No.
Even with would you allow an employee of the assessor's office in to review the equipment?
I believe so.
Well, what would be the difference? So what would be the difference if we had an agent, which we hired as an agent of the county? I'm not sure I see the difference. If they were an agent of the county, we had contracted with, and that person was accompanied even by an employee of the county, the assessor. You're saying you would not allow that person on your property to evaluate that equipment?
The consultant in question, the outside consultant in question, right? That's who you're
That's
referring
what
to?
I'm talking about.
No, we would not.
If it were another consultant, would you allow? Is it just that particular person and you'd have to, would you allow?
I don't know.
You
I
don't
can't answer
know.
that question.
But Tim, I guess I'd ask you as a representative of the county, if that person is an agent of the county, you feel that they have a right to enter the property to
I think that-
evaluate?
I think
We
that-
can contract somebody to do that.
Along with the tax assessor has a right to determine the true value of the property, including inspecting the property, and if the tax assessor needs expertise to hire somebody to have expertise to do so, I think they have the right to do that.
Ma'am, address the board.
Because we have other agents we hire to evaluate property, for example, the casino.
We do, absolutely.
The casinos have never not allowed them to come on.
Nope.
And
Not that I'm aware of.
Okay.
They do it every year, Jake, what's it, Puckett and,
Right.
who is it? Pickett, I'm sorry, not Puckett.
You said you wanted.
Same
just-
thing.
Yes, sir, I would
Yes.
I would just state that under the statute, AT&T is within its rights. The tax assessor and the tax assessor's deputy have a statutory right. Other contractors with the consent of the taxpayers would be allowed on possibly, but the taxpayer is within their rights to say, if you're not the assessor or a deputy, you're not coming on our property. That's.
But the other side of that coin is, the board has a right and has asked y'all to
Yeah,
produce
until we can
documents.
verify,
Excuse me?
until we can verify that what y'all are giving us, having somebody do it, I mean, I'm not willing just to accept, okay, this is what we have. If we can verify it and what you say is correct, then
I'll
we'll
say
talk,
the
but
same.
I mean, I would love to just say, hey, tax me $1,000 for my house, it's not worth anything. That'd be great for me, if I could get by with that, but I can't get by with it, I don't think a company should be able to either. So I'm not willing to even really listen to what you have to say until our people can verify what's on site.
One other clarification, I want to make sure I understand it. The county is the county in this particular objection claiming that the statute that's been modified, that he referred to the governor signing, we don't have an issue with that being,
I don't think that changed
under the
this.
law now to be exempt?
I think,
That's the question I'm asking.
I think that's to be determined.
That's to
There
be
is some
determined.
there is some interpretation in that. There are pending cases where that issue hopefully be litigated and determined. That's a separate issue.
In reference to the new law that you
Right.
referenced in
Well-
March being signed by the governor.
The legislature attempted to clarify what was in the previous law, is what it appears to me to be, so we hadn't gotten to that point yet. What this is about, this doesn't have anything to do with the exemption issue, this has to do with,
That's what I'm asking. This is actually, the issue before us is whether we had a right or actually saw the properties that need to be evaluated.
well, you gotta remember, this taxpayer is appealing to the board. It is their burden of proof. If they are not allowed, if they have not allowed the tax assessor to make an assessment of the property, true value, and they probably have that right, I'm not disagreeing, they could shut the doors and say, don't come in. But I think this board has a right to say, we're gonna take the assessor's opinion over yours because you did not allow her to inspect it.
Well, we did not allow the tax assessor.
Tax assessor's agent, look, let's don't play games. Neither I or Paula would, you know what I know about a cell phone? It's right here in my pocket, that's all I know. So to ask me or Paula to go into the cell tower and to tell this board what is there and not there is, quite frankly, playing games. They hired an expert, the board entered into a contract with them to assist and determine, just like we've done with every casino. And we have, Pickett goes in every year and does a rendition, not every year, every so often, and does a rendition and tells us whether those values are valid or not. Same thing with CTS, I get it wrong again. They go in and help the tax assessor make that determination to advise the board. And if AT&T is gonna stand in their way, then the board has a right to take that in consideration and consider in their appeal. You have the burden of proof. And the board may well decide that you did not comply with the law in producing what was been asked of you to produce to the board. You may be prohibited from appeal, that may be our position on appeal. So, I'm not saying yet, the board hasn't made a decision, you may win, I don't know. But it does not sit well to tell the assessor that she can go in there, but you can't have a person that the county has hired to assist her go in there because y'all have some reason, which, you correct me if I'm wrong, my understanding of the reason is that CTS used to work for AT&T, is that correct?
No.
Is there some other reason?
Well, sure, I mean, we have we've been dealing with CTS all over the place,
All over the country.
all over the country. That's correct. And, we have a fundamental difference on what they do and what we do. All right, we follow the guidelines, they don't. And, we've learned in the past, CTS makes guarantees in their contracts. So why would we take them in to help them? They're using an unreliable method, they got a bias toward a desired outcome. And as we've seen before in these hearings, they have a tendency to play fast and loose with taxpayers' confidential information, as they discussed their relationship with Dish. So those are our issues, not that somebody used to work with AT&T.
So have you raised those issues before now?
I haven't personally.
Would it not be, not being an expert on, like Tim, I have enough trouble using my cell phone.
And I'm an AT&T
But
customer, by the way.
Would your argument not, would you not have a better argument before this board if you would allow them to access your equipment and then come in and argue that the appraisal of the equipment is not correct? If you'd allowed our agent to evaluate the equipment that they needed to go in, or you would not allow them to see. If you'd have allowed our agent to go in, evaluate the equipment, and then argue about the evaluation, that it was incorrect or not, properly done, or whatever, to argue that, rather than argue that they don't have a right to access it.
Well, I understand your comments, but for the reasons I just stated, our stance is that we're not letting them in.
Then we don't.
See, I'll make a motion to deny the claim. I mean, until you're gonna allow us to verify what's on site, I'll make a motion to deny the claim.
Our second.
And then, any further discussion? All in favor of the motion, say aye.
Aye.
All
Aye.
opposed? Motion carried.
Thank you, board.
Thank you.
Oh, yeah.
Yeah, we're talking, I have to put one of them scanned on here as part of the record. You want it scanned in as part of the record?
Yes.
I agree with you. I got this one back
Get
here.
it out of your hair.
Now, yours looks different.
Walmart, I talked to her.
I want to keep mine. Yeah.
If they did. I don't know why. But that's what we just approved on his. I thought we just approved their withdrawal. Did they submit this before the withdrawal? Move the question, move the point.
What's that?
On Walmart, none of this is out there.
Oh, they
What
went
they
through
submitted.
Walmart?
That was printed prior to that.
You want me to help you out? Here, I'll come back. Yeah, I know.
We have to.
What's new?
Come on down and get some.
I have liquor, you want me to go get some from her?
No, I don't.
Well, we'll see if we win.
Should do anything, get out of here.
You get up on ceasefire, they let you.
I've never heard of that.
Right, I knew that, that's why I said the question. Good to see you again, how you been? Y'all let us do this, so we're okay. I used to be, I was a switch. That wasn't mine. That was mine.
I got a brother.
Good to see you. How you been? Great. I do have a client that's a big ceasefire customer. I have to tell you a funny story about him.
As long as he just talks about how great service he had.
Oh, he still got
Any
ceasefire.
problems and that kind of thing. That'd be
No,
fun.
it was a funny story. You would laugh. I'm telling you one day. He went to ceasefire and got him. He was a minor, and so I managed his money. It was just some funny stories about him and ceasefire.
Okay.
The manager out there used to love to talk to me about it. I'm sure that stung a little bit, that was hurt. I don't think the oath was proper either, we should have added that to it. We'll do that sometime.
I want to be a little careful.
I just told her I hope my phone didn't shut off in the next 30 minutes.
I did make notes about those.
Can't hear you. Yeah. Forty days. They haven't decided that.
Can't go back. Where's Kent?
No, it's just a small order tonight. I don't know what the reason was.
Oh, there he is. I thought you left.
Well, this one, they have reason for stuff ordered. I don't know what the reason for it was, but see what they said, and then decide what to order. Wait till after this meeting. I know that, but you're not in my mind. I'm trying to think. Wait till after this, we'll figure it out. Yeah. Nathan Joe.
And they come in.
We're still not.
But they're not even allowed us to check. Okay. Y'all ready? Yeah. Y'all
I
ready?
think we'll wait till
Oh,
that.
One more minute.
That was 15 minutes.
Oh, yeah, okay. I think squeeze this chair. Let's put it straight away. I can walk in without making noise.
I'll order 38 for
Can you hear it, Aggie?
I can.
That aggravates you, doesn't it? Doesn't that aggravate you for somebody to be making a noise
Well, Dan used to sit here next to me in the meeting and do this the whole time.
with his pen? Yeah.
And I would take
I
it,
know.
put it down.
Yeah.
I just figured mine was either a buy or a load.
Yeah,
That's why mine was.
Yeah. I know that when you're making a noise like that, people got to act.
Deer stand there. I mean, you have 10 deer upstairs. They're gone.
Because you have to go scan that. Once you scan.
We had a deer camp up in Benton. Somebody told me it was a big deer. We'd seen, we figured out I got a well before day. I walked in there, creek in there, I couldn't stand I'd done laid back like this. There it was, I had my gun set up.
Make you move.
As soon as I said, they're all going.
And made a noise.
Ready?
Yes.
Okay. All right. Next up, we're gonna recognize representatives from ceasefire to discuss the 2025 property tax assessment protest for assets located in the first and second judicial districts. Just also, we have a third supervisor on the phone, Supervisor Record Howell. So I guess we need to get, okay, go ahead. No,
Same thing.
Yeah.
He has no objection.
right, you don't have
Here
any
it is.
objection first.
We have no objection.
Okay.
And I'm
Say your
Kyle
name.
Williams. I'm with the Brunini Law Firm. My law partner Sheldon Olson is here today. We're also fortunate to have Joseph Malfray with Ceasefire. He's the senior manager for field operations. Joseph's great at his job, and so if you guys have some technical or more process type questions, hopefully one of the three of us will be able to get you an answer. Thanks for the opportunity. Again, Kyle Williams on behalf of Ceasefire. You've heard a lot of these issues this morning already, the broadband exemption, the valuation process, and so I'm going to do my best to streamline my comments. Don't want to put you guys through that twice. Let me just first say, we were here last year substantively on the same issues that we're here for today. That objection from last year is now in a tax appeal pending in the circuit court. And so we're working through that process with Mr. Holloman. But there's a couple of things that have happened since we were here last year that I just want to share with you right quick. So first is in the early summer, the three of us, three other individuals with Ceasefire, your consultants with CTS, and gosh, probably 7 or 8 people from the tax assessor's office went and spent nearly a day touring Ceasefire's facilities across the county, a selection of those facilities, a selection chosen by the county. I forget exactly how many sites we toured, but we spent a good while going onto site there. We spent long time staring up into the sky at the equipment. But importantly, I think, and helpful for Ms. Ladner's office and for the county's consultants, is we were able to open those doors on those cabinets that are at the bottom of some of those cell phone towers and allow them access to go inside and put their eyes on that equipment. Joseph was able to go in there with them and explain what everything is and answer any questions that they had. And if I recall correctly, we went to so many sites that the county's consultants finally said, we're good, we don't need to go. We had planned to go to additional sites, and the county consultants were like, we're good. So we felt like we got a good cross-section of these fire sites across the county that day. But importantly, going into that day, going into those inspections, ceasefire provided itemized, detailed invoices and other company records that support the cost that ceasefire paid for all of those assets that we were gonna be looking at during that inspection. So it's one of those binders there. It's voluminous, and so there's a lot of documents there, and it breaks down individually. Every asset that is on our rendition for those specific locations, you can go look at those documents and see, all right, let me look at this item, and you can see when it was acquired, who we acquired it from, how much we paid for it, and so all of that was provided in advance of those inspections. And then maybe it was actually provided the day of the inspections, but they've had it since then. So all that was so that we could try to be transparent, so that we could try to demonstrate that, number one, we want to work through this process, but number two, and most importantly, it shows that what we put on our renditions is correct.
But Mr. Williams, what, and I'll ask Paul and the issue then with you is we had access to whatever we wanted to see, the assessor wanted to see. Is that correct?
We did have access, we were furnished documents towards the end of the inspections. I think part of our issue is the wide discrepancy in values between sites, just looking at equipment. If I'm not mistaken, they're all pretty much cookie cutter. There's nothing in one tower that would never work on the other. If there is, it's very limited. So they're pretty much cookie cutter, but the values they render are wildly varying. And the information they provided really shed little light. It was work orders, it was hard to identify what the equipment was and where it fit in the system.
So you're saying, if I understand right, what you're saying is the paperwork that they submitted in reference to the value of any particular piece of equipment, you couldn't verify or it did not address the actual value of the equipment?
It was hard to tell exactly what we were looking at and where it fit, what exactly it was, and where to find it on the rendition. I spent hours and hours and hours going through trying to figure out what the receipt or the work order that they sent, where it fit in the rendition. Trying to compare those two values, I'm not sure if I found more than 2 or 3 that I could verify that here it is here it is on the rendition.
Mr. Williams?
So it was a lot of stuff, but it was hard to make sense out of.
Can I ask
What-
a question?
Yes, sir.
Robert, did they provide a rendition on each separate tower, or was it all grouped as one mass?
No, each site is rendered individually.
All right. And then amongst those renditions, you found, even though they were cookie cutter, as you call it, or
Yes.
what you mean by it, the sites are basically the same.
Yes.
There was a variance between the costs that they provided on those similar towers.
Yeah, the values, the taxable value that they were claiming, just wide variation.
Was there any explanation given for that?
Difference between taxable and not taxable would probably be the most common.
I mean, exempt?
Yes.
Any explanation of how they divided that? Why would it vary so much between towers?
Let me just say a few things. Obviously, as a company, we have internal company records that we can provide that demonstrate the original acquisition cost new, which is the standard here. All we can do is give that to you. I don't know, if our company records aren't enough to demonstrate what we pay for the equipment, I don't know that there's any documentation in the world that would satisfy the assessor's office on this
Well,
point.
if he's submitting to you the acquisition cost of a particular piece of
Yeah, if I
equipment
can't
that doesn't
identify it on
satisfy
both-
us, Robert?
If I can't identify what it is on both sides, they may get, I may get a value. And it was a lot of paperwork, but it was, most of it was unuseful. If I had a receipt for an antenna for $12,000, whatever the cost was, I couldn't find it in the rendition. So if I can't find it on both sides, how do I know that we're talking about the same thing? I don't know that this is actually this over here.
So our company, our records, the records that we handed over, they have asset numbers on there. And I will tell you, we would have been glad to answer any questions had someone contacted us to tell us they were having problems reviewing the documents. One of the reasons for the variations in cost, I think this is a great point. Keep in mind, as I mentioned, the cost is based on original acquisition cost new. And so if you have two assets and one costs more than the other, then our renditions are gonna reflect that those costs are different. That reflects that we're showing we paid this for this asset on this date, this for this asset on this date. And so the fact that there's differences in the cost of the assets, I think is not in any way a basis to disregard what we're saying.
You're gonna have to help me out, because I get a little confused here. It seems, maybe I'm looking at it simplicity. You have a receipt of a purchase of a particular item. Okay, you have, at your company, when you buy that, you get a receipt for it. Does that receipt have on it any kind of identification numbers of the item that you're purchasing? Like, I use a serial number. So when you submit to the tax assessor, acquisition cost, some paper that proves you acquired this at a certain cost, does that paper identify that item, like a serial number or some other identification, that the tax assessor can look at it?
Or work order where you installed it on what type
Of
of?
something that-
Is that what you're referring to, Robert, when you say the other side? Where they maybe installed it, a piece of equipment?
A lot of times it'll show, acquisition costs, then they'll depreciate it. I think the issue is, there was a lot of good information on what was exempted, and perhaps not as much on the stuff that wasn't exempted. All I know is it was hard to go between both sides and try to verify this is exactly what we're talking about. That was my takeaway. It may have been just the way it was sit in the rendition, and later on, we're trying to get receipts for it, but it was hard to go back and forth and verify exactly what we were looking at on both sides, everything. Going through the stuff that we would consider, that both sides would agree was taxable, I was having a hard time verifying on both sides, purchase prices, acquisition costs, and things like that. There may have been a few, but a lot of it was just hard to pull it apart. I struggled with it, I think, I'm about for about 8 other people that had a problem with it also.
So let me just say again, I mean, the records that we have are the records that we have. I think us opening up our gates, going and attending that full day almost of inspections, providing these documents demonstrates that we want to work with the county. We're trying to be interactive here and do everything that we can to help out and make this as simple of a process as we can. And so if there's questions like that, you've given us your documents, we can't really connect all the dots here. We would appreciate being notified about that, because we have people that can connect those dots very easily and answering the questions that the assessor's office may have. We weren't afforded that opportunity, but I think our track record here demonstrates that we're willing to do that.
Do y'all haven't established what you feel the value is?
Well, we think that the value should be based on the values that are in our renditions.
Okay, do you have a value stated on that, on your
Yes,
rendition?
for every asset,
Okay,
individually.
and has the county submitted what they feel is the value?
They have, I think we've seen.
What's the difference,
property
is what I'm
record
trying to
cards.
find out, what What's the difference in the two values?
Well,
What you
it's-
claim and what they claim?
It's substantial. It's hundreds of thousands of dollars tax value, not value, but the
I
actual tax
understand.
that's due.
The actual tax.
And, you know, I would just tell you that it's based off primarily the same two issues that we were here last year to talk about. It's the assessor's office refusal to apply the broadband exemption, and it's the illegal valuation methodology that's being used. I'm only gonna spend a couple of minutes on each of these topics, because I know you've already heard about them. You've heard about the broadband exemption, you've heard that it was recently amended, and I'll just cut to the chase and tell you that substantively, that doesn't change anything for us this year. Our equipment qualified for the exemption before the amendment, our equipment qualifies for the exemption after the amendment, and so substantively,
So a broadband exemption is not applicable to y'all.
it's very much applicable.
So what I mean is that there's no contest, because you said, your argument was that y'all y'all qualified for the exemption prior to the amendment.
But we weren't
of the-
granted it in Harrison County.
But you were not granted.
It qualified.
There's an issue about
That's
this.
the issue, that we
There's an
can't.
issue on appeal about whether they contend the
That's
exemption
right.
applies and, the county contends the
Yeah,
exemption.
so that's still an issue that's gonna have to be settled.
Yes.
Okay.
And we would just say that our equipment qualifies in Harrison County just as it does in the 78 other counties that granted it for us last year and this year. Harrison County is one of 4 counties in the whole state that did not grant it. All 4 counties have retained CTS. There was a 5th county, but based on what the tax assessor in Lamar County is telling us, they've done a 180 and walked away from CTS's interpretation of the broadband
I'll be
exemption.
honest with you, it doesn't affect this board very much to have a notice.
That's fine.
We have all kind of issues where we say.
Understandable, I'm just giving them background. I think it's
They do
good
that
for you to
for-
know what
they do
78 other counties are
They do
doing.
that for a variety of reasons, and so some of them don't want to spend the money to defend the cases, so that's kind of where we run into it, including Lamar County. So, I'm not saying anything other than there's an issue there that the courts are gonna have to decide eventually. I think Jasper County is probably the farthest ahead.
We have a trial date in Lamar County, so we'll be going to trial in Lamar, first of next year.
But is your real issue the exemption?
It's both,
Not
it's both. So the
granting
first part of
exemption.
it is the exemption. Again, the law changed slightly, and yet it looks like, based on what we know, CTS still believes that our equipment doesn't apply.
Let me ask you this question, I don't know if it's reasonable, but theoretically, if the Board of Supervisors told you we were gonna grant you the exemption, how would that impact the two values? Would we be more in line? Is that a reasonable question? I'm simply
I think
asking.
Paula can answer this, but you're talking about $30 million versus
Well,
$3
my
million
point is,
of assessed value,
I'm trying
or
to
exemption.
find out really where the exemptions are.
Well, maybe,
Where the
since-
difference is, Tim, if we were to grant the exemption, okay, I'm just saying theoretically,
I think.
then what about the difference in what you're saying is a reasonable, evaluation and what they're saying?
So if to answer your
If the
question,
exemption was granted, what would be the difference then between what the assessor is saying and you're saying?
so if you granted the exemption today, we would be a lot closer to the difference in value.
So the real crux of the issue then is the exemption.
It's certainly a part of it, but the second part of it,
But the main part of
Help
it, the
the
major
board
part.
by explaining your position on the exemption, the broadband exemption.
yeah, it's
I'll let you give your spiel.
It's very simple. The statute, even as amended, sets forth certain requirements for to obtain the broadband exemption, just like it always has. Now, parts of some of those requirements, not all of them, but parts of some of those changed this past legislative session. Our equipment meets all of those requirements.
And broadband, what he means by that is internet access versus cellular.
I just mean, if you go read the statute, we apply, so I think the statute speaks for itself, but our equipment, I'm representing to you, just as what was represented in our renditions that were signed under oath, where we note every item, every asset we have that's entitled to the broadband exemption, we note that specifically in our renditions, signed under oath, and so just as C Spire's employees represented to the county, I'm representing today that our equipment meets the criteria.
Oh,
And I
this is
haven't
part of
heard,
The oath, can I ask you, does that oath comply with 273523 subsection 4?
this is the oath that's in the renditions that are, I presume, used by nearly every taxpayer in Harrison County as approved by the Department of Revenue. And they might even be available from the tax assessor's website. That's, it speaks for itself.
I know, but the statute says it's the duty of the taxpayer to comply with the statute, and that oath does not comply with the statute. Do you agree with that?
I don't necessarily agree with that. This is the oath that we execute. We might just have to disagree on the statute you're reading, whether it,
Do you agree that the
Is that-
statute quotes the oath that's supposed to be on these renditions?
say that again?
The statute actually quotes what oath is supposed to be on these renditions.
I'll take your word for it. I'll just say the statute speaks for itself. If that's what it says, that's what it says. We submit the
It was
renditions.
just on my
that-
notice this morning.
So, we have the broadband issue, and again, succinctly stated, our equipment qualifies for it. We meet the speeds. The speeds, I think, are the crux of Cell Tower Solutions' position. They say that our equipment doesn't qualify for it because of the speeds. The speeds, our equipment meets that requirement. So the second issue is the valuation. And I think this gets into your question a little bit about if we get rid of the broadband issue, what are we left with?
Yeah.
So we've heard a little bit about the valuation issue today. At a high level, Mississippi law authorizes the Department of Revenue to set out how the valuation process is to work, okay? The Mississippi Supreme Court has said that when MDOR does that, that assessors have to follow it, okay? So MDOR has done that through the regulations, through what they call the appraisal manual. And for industrial personal property, which is what we're dealing with for C-Spire, the Department of Revenue has said that you have to use original acquisition cost new. So what does that mean? That means, what did C-Spire pay for it when it bought it? Well, again, we've given our invoices for that selection of towers that the county selected to demonstrate what C-Spire paid for it when it acquired it. And you know, fundamentally, Cell Tower Solutions and by extension, the assessor's office, they are not objectively not using original acquisition cost new. They're just not. Historically, Cell Tower Solutions has gone online and gotten their costs online of what some random seller, I don't know if it's a retailer or a wholesaler, is selling that piece of equipment for. But that's not necessarily what C-Spire paid for it when C-Spire purchased it. That amount is reflected in our renditions, which we have given to the county. That amount for those towers that we looked at is evidenced by the invoices that we provided. And so CTS is wholly disregarding Mississippi law governing valuation for ad valorem taxation purposes. And I don't know that they can objectively argue otherwise. So that's our position, the same as it was last year. The law is clear on how this process works. The process is not being followed. And for the broadband exemption,
Address
we
his issue,
qualify.
Robert, is that you're not following what he's saying, you're not following the law.
It's not the law now, that's.
Pardon me?
You're talking about the manual for the Department of Revenue, which the Supreme Court, I agree with you, has said that you're supposed to follow the appraisal manual.
A regulation promulgated by the Department of Revenue is treated as the law. It might not be a statute, but it is treated as the law.
It's basically, the Supreme Court has said you're supposed to follow the manual, so.
But yeah,
But
you
it's
have
not,
to
it's
follow.
not the statute. Go ahead, I'm sorry. Go ahead, Robert.
The information that was provided was, it was a mess. Good word. It was hard to use. I'd like to see anybody that doesn't work in the industry for a living go through and try to make sense out of it. It's very difficult. A lot of the receipts were stuff that was exempted. So where, if they contend that their problems are with things that are not exempted, I think we would have had better information furnished for that at least. There were work orders, they were old work orders, they were, not necessarily receipts from the suppliers, they were between departments. Am I wrong? It was hard to use, period. You can give it, but it seemed like it was just a bunch of smokescreen, to be honest. It was very hard to use.
I don't think I can direct my questions to him, so I would just pose it to you. If what we provided, which are our records that evidence the cost that we paid, are a smokescreen, and they're too confusing for the assessor's office to understand, what can we provide?
I guess where they,
I mean, I hear a bunch of generalizations, but I don't hear a specific concern. We can't find this item, this asset, we can't find this on your rendition. Or we're looking at your rendition, we can't find an invoice for this asset. What we did was, before these inspections, if I recall correctly, we did not differentiate between what is exempt and what is not exempt. We said if we're gonna go to this cell phone tower site, we're gonna try to get you an invoice for every asset that we have out there. And so we didn't say, well, let's only give them the ones that aren't exempt. We said, let's give them everything. And so
were they asked for clarifications on any of it? I mean, were they addressed? We need clarifications on this particular items or something. Maybe I don't understand, but it sounds like what they're saying, they offered their cost, their rendition. Where they then questioned, listen, we have some problems here, we can't get information, we need more information. Where they?
I believe they were.
They were?
Yes. I spoke with the lady, one that was in the field with us at the inspection here back in April. When we got the binders with these invoices and all, I could not make heads or tails of it. So I spoke to her and asked her where these prices come from, because there's so much inconsistency in these prices. She told me because all she could tell me that she knew was because they buy in bulk. They buy in bulk. That's all she could tell me. I asked her for the second request also for insurance policies. What do you got these towers, the equipment insured for? Oh, I'll get that from you. I asked her in the field, I asked her on the phone. I have yet to receive anything. There's no, when you do what we do, it's very hard to look at these invoices right here, and like Robert said, and trying to find this piece of equipment on the rendition. It's impossible. And I'm not stupid. I mean, I might be a little slow at times, but I'm not stupid. And
Trying to match with a
challenge-
serial number or.
Yes, and I can challenge you to try to find the
anything
same
that you
thing.
can try to tie it to back
You
here.
can't.
That's what I asked earlier about the serial. Maybe I didn't understand. I was asking about the serial numbers. That when you've got a piece of paper that they claim purchased something and there's a value on it, you got to be able to identify that particular item, that particular invoice or whatever, to a particular item, and you're saying you can't do that.
I
There's been
tried.
several things we asked for clarifications on and additional information. Site value at the port was omitted from their rendition. It was discussed at the port, and they told us we'd get the information. We asked for it again since then, we didn't receive that.
it sounds like an isolated issue. We can certainly look into that isolated issue. I don't know that has the bearing on the document. I mean, the documents provide an asset number. Am I framing this correctly? They provide an asset number. Again, if there's an issue with connecting the dots, we have people that can do that. We've shown our willingness to drive down here multiple times to meet with you, meet with your representatives. We would gladly do that again to walk you through these documents. Look, are they simplistic to follow like a storybook? They're not. They're not, but we're talking about a lot of assets here, a lot of values. It's a complex operation. Unfortunately, it is what it is.
Are these towers insured? On the schedule where you can tell what the value is that you insured them for?
So I would say, we don't own the tower, we own certain equipment on the tower.
Is it insured, even the equipment?
We don't do it individually.
Yeah, we don't think we do it individually.
Well,
But
typically, insurance companies, like they, just just like the county. We insured all the buildings. They had somebody that came around and did a survey of every building
Mm.
to make sure the values that the county was requesting on the insurance policy was consistent with the values, so they're not overinsured.
Yeah, well, I would say this, Tim, and I think you'll appreciate it. If the assessment and the valuation for assessment purposes is supposed to be made on original acquisition cost new, that's what you paid for it, then unlike the real estate context, the insured value might not really at all be relevant here.
It's, look, back in the mid-eighties, my first burden in life was to help my dad with board supervisor. We tried dozens of these tax assessment cases. One of the things that was important in all those cases was how much they insured their property before. Because even though you're gonna say, okay, the acquisition cost is the actual cost, whatever you insure it for gives you a perspective of whether that's true or not. And so the insurance value is actually the best value, in my opinion, of what somebody says their property's worth. And we won many cases where they would say it's worth $100,000, but yet they went and bought insurance for $300,000. Now that's different because it's not a cell tower, I understand that.
Probably not industrial personal property.
But at some point in time, if I would assume that ceasefire insures whatever equipment it has out there, especially in the area that's hurricanes.
Mm.
Somebody did a value on those towers. It may be replacement cost, it may not be, but it does give a reference that the tax assessor can use in doing, in trying to see if the rendition that has been made is appropriate or not. So.
Well, we'll follow up on that. We will. But I would
I
represent.
start looking at things, I see the oath that the statute requires, and it says some very specific things the taxpayer is supposed to, under oath, state to the board. Statute, not some form that the DOR created. But that statute's very specific, and when you read it, I think there's a reason that it's very specific. To try to make the taxpayer understand that if they don't do what they're supposed to do, they're, one, committing perjury, number two, they're gonna lose their ability to contest that tax assessment. Which is why I think that's important, but either way, the exemption is a different issue that's going to be a legal issue at some point in time. I want to hear what y'all, the broadband exemption has to do with internet, correct? Now they've clarified it, says it has to be a certain speed, right?
Yeah, it requires a certain speed.
But the cellular towers don't just have broadband, I mean, just like my phone. I have AT&T, so forgive me. But, you know, we spend a lot of time on the internet, that's what you mean, on the phone. That goes through that cell tower. So your position is that part of that cell tower is exempt under the equipment related to that is exempt under the statute. The parts that relate to cell towers are not, right?
I think the statute talks about an asset being capable of doing X, Y, and Z, and so what we're representing is our assets are capable of that. Our assets meet the requirements in the
We just
statute.
love the legislature, and what they write. Good for lawyers, but not good for making decisions, so.
We thought the issue was quite clear until a few years ago.
Well, I mean, the board's problem, just so you understand, is they're sitting here trying to, you know, pay for whatever the taxpayers need or fund whatever the taxpayers need in our, public needs in our county. And when somebody comes in and gives an exemption on $30 million worth of assessed value of property, and the county loses those taxes, and Mr. Ladner, and Mr. Powers, and Mr. Jones, and Ms. Powers, and Mr. Jones have to make that loss up. And guess where that comes to? My house, their house, everybody else's house.
Somebody else pays.
So it's not just like it's not just like this, okay, we're hurting ceasefire, hurting AT&T. When you lose that tax base, somebody grants an exemption like that, that money has to come from somewhere to pay for the roads and the courthouse and the jail and everything else. And so where it ends up going is somewhere else. Either the county has to reduce services somewhere else in order to make up that shortfall, or it has to raise taxes. So that's a problem, and that's not your fault, that's the legislature. We're all in favor of creating broadband internet access in the rural areas to help people that don't have internet access. Harrison County is not really a rural area. In fact, I just recently was provided a map. Most of y'all cell towers are in the cities. They're not in the county. They're not in the rural areas. Very few of them are in the rural areas.
Well, I would just tell you that the statute makes no distinction
I understand
whatsoever.
that. Well,
So, all we're arguing
I
is
agree
that,
to disagree, and we'll get that through the courts
Yeah.
eventually, and you're probably gonna be right, because the legislature wrote it the way they wrote it, but we'll figure that out within the court system. So I just want the board, to really what you talk about broadband, you're really talking about internet access via cell phone.
yeah, I think there's a specific definition of broadband that
Yeah, I've read it, I'm putting it in layman's terms.
Do y'all feel, Paula, Robert, that he seems to be offering some communications with you, solving
We've
some
had-
of the,
We've had great communication with.
with them to get it as far as identifying those items and their value that you're having trouble with?
We can try.
Are we talking about, what kind of time period are we talking about?
I don't know if we'll have anything by next Monday.
That's your deadline.
That's the deadline now, yeah.
Well, nothing prevents it from continuing to be discussed even after appeals file.
So we basically,
Right, nothing
you're
prevents
saying-
it from resolving this on appeal.
I think we're in a position like similar, not exactly, but at least similar to the last one, is to deny it.
Right.
Because start with, we seem to be at odds with the exemption. Taking different positions on the exemption, so, and that's the real meat of it.
certainly part of it.
Correct.
Ms. Bladner, I would, just out of curiosity, if I could, I would love to know from your consultants, if they can point to a specific asset we have and say, that asset does not meet this speed, it only meets X speed. Because the issue that we've had for years with CTS is there's a bunch of generalizations and a bunch of high-level statements that sound great, but when you actually dig in, you can't get anything. And so, my curiosity is that we say that all of our equipment satisfies the exemption, and we note that on our renditions, signed under oath. And the response we get back is, no, we're not gonna give it to you. And so I think it would be helpful for us to know which assets do you contend, because we're not getting it for any assets, is my understanding. It's just a blanket denial.
Then I would ask Tim, where are we on that as our agent giving him the information that he's requesting, Tim?
Well, I mean, there's a legal issue that has to
That's
be
right.
determined, and it's a legitimate position, they're not being criticized for taking a position. But literally, when you read this act that was originally passed, it was to promote the development of broadband internet in rural areas. That's the specific prelude to the statute. And it goes through and talks about tier 1 counties, tier 2 counties, tier 3 counties, and what that's serving, and that was the intent of it. When it gets to the exemption statute, it grants the exemption and never mentions tier 1, tier 2, tier 3. So the interpretation by the cellular industry is that it applies to all of it, regardless of whether it's in rural areas. And that's gonna be a legal issue that the court's gonna have to determine. I don't think the board should, nor do I think the board can make that decision that says all the cellular tower broadband is exempt for 10 years. It's 10 years, isn't it?
10 years.
And so, because of the cost to the county, and I talked to the board once before about the difficulties of this issue. It's similar to the Section 8 housing issue that cost this county a bunch of money because of, Cook County had to make up for it. These exemptions are unfunded mandates to counties, unfortunately. So the question is whether or not that exemption applies to tier 1, tier 2, tier 3, or all tiers. And their position is, quite simply, is the section dealing with the exemption does not mention the tier 1, tier 2, tier 3 hierarchy of these exemptions, and so that they take position that applies to all. That's basically it. And, I'm not prepared to tell this board which one it applies to. I think the court could determine exactly what they said. If it only applies, it applies to all. But I think a court could also look at the overall intent of the statute and say that, no, this was for the purpose of granting exemptions to promote the development of broadband in rural areas, not for, areas such as Harrison County, so.
I would note that even the franchise taxes that are afforded, they apply to tier 1 counties.
I understand.
So I think you can read the statute even with an eye toward that view, and I think you still can arrive at an interpretation that says that no exemption can be given in a tier 1 county.
It's something the legislature didn't make clear, and that's not unusual, that's all I can say, and it hurts the counties, so.
I guess our position is that based on the tax assessor's, position in reference to the exemption in ours, is that we deny
Yes.
the
I would agree.
appeal
I have a feeling when we get a decision.
until
something
this
like
is
that.
settled.
That may be a summary judgment early to get that argued out,
I hope so.
So
but we
that,
haven't done it so far.
I will make
Make a
that in
motion.
form of a motion.
I don't know if that trial's gonna go in Lamar County or not.
Supervisor Powell.
That's gonna only be on,
Rebecca, you
Lamar
there?
County's taking a different position on the exemption now, aren't they?
At least for this current tax year. I think for the tax year that is set for trial, there's at least one tax year set for trial that broadband issues
Just
implicated.
so the board knows, you brought up 78 counties. The problem we're dealing with, 78 counties are all rural counties, most of them. They don't, it doesn't bother them. In Harrison County, just with ceasefire, it's $30 million. That's a.
Yeah.
Yeah.
Well, we don't have appeals in Hinds County, Rankin County, Madison County, DeSoto County, Lee County, so Forest County. So I think there's lots of
They
examples.
granted the exemption.
Correct, in full, as they have, as all counties have for decades.
Okay, no further discussion on
Well,
the
oh,
motion.
CTS would
Yeah,
like,
we'll make it, we're gonna make it as quick as possible, because it's been a long discussion.
Wait a
First,
minute, yeah, hold on, yeah, we got a motion.
Okay.
Yeah, excuse me, can you repeat,
Hold on.
that motion, please, sir?
yeah, or do you wanna,
We have a motion on the floor to deny the appeal.
do you wanna hear from CTS? If not,
We
that's
can,
fine.
that's what I was asking.
Right.
What do they, yeah, I withdraw the motion at this point.
Okay, we'll try to make it quick, so, but we'd like to kind of fill in some of the gaps and holes for you regarding, what, ceasefire said. I'm Walter, I'm with Cell Tower Solutions, this is, Chris Shrewsbury. First of all, I want to thank Yep.
What was
You
your
couldn't hear
name?
you.
Walt Woodard with Cell Tower
Walt.
Solutions and Chris, just Walt and Chris.
Alright.
But,
Walton Chris Show.
yeah, the Walt and Chris show.
Excuse me, before we continue, I'd like to second Supervisor Ladner's motion,
Well,
please.
I went through that motion because we're
Oh,
gonna
okay.
hear from CTI, Mr. Fowler.
Yeah.
Yeah.
But first of all, want to thank Joseph and Sheldon and Kyle for allowing us to go out to the sites. I do appreciate that. We've done a lot of site visits with a lot of people. Just to kind of reiterate, Chris started with AT&T he's an electrical engineer. He started with AT&T as a design engineer, designing the sites. He then went on to go into implementation of a $1 billion project in Atlanta. Then he went on to work for Bechtel as the systems expert, coordinating between Bechtel and multi-billion-dollar projects. And then he went on to work for the equipment companies. So far as what we provide an engineering approach to these sites. We're completely 100% objective. We just see ourselves more as the referees in this. We didn't speak with the AT&T people, but there are many times where we'll see more assets there, or excuse me, they'll report more assets than they actually show on the site, which is crazy. Their numbers are all over the place. Ceasefire, we've been talking to them for 3-4 years, and we do believe that they're making an effort to provide the best data that they've got. I think it's been stated to us from Ceasefire, our systems are not necessarily great at record keeping and keeping up with what's out on site. And this pretty much fits
all of the cell companies. I was talking with Sheldon beforehand, and I said, one of the leading people in the industry, in the tax industry, told me one time, he said, we have 60,000 sites at AT&T, and he said, do you think we know everything that's out there? He said, absolutely not. He said, our systems are not really good at that level of record keeping. And so what we do is we want to get down to the granular level to look at the key systems out there that operate the cell site. About 90% of that is going to be the core systems, which are radios, antennas, the fiber cable, power systems. All of that is going to make up about 90%. What C-Spire sent, and when you really cut it down to the chase, what they've done is they've tried to send pretty much a complete inventory, which we never want. I tell counties, never ask for a complete inventory, because 90% of your cost is going to be in probably 10 to 20 assets. 10% of your cost is going to be in, and this is one of the documents here. This is a zip tie. There's 8 of those at 48 cents for $3.84 total. There's
Sorry, zip tie?
Yeah, that's on there for zip ties. Cabling, accessory, hook and loop, so that's Velcro. $21 each for 5 of those for $105.46.
I would say this, I'm not an attorney, but I've been around these guys for about 8 years now, and they're pretty good at this de minimis stuff, it's like throw it all over the fence and you figure it out.
Yeah.
That's what this is, okay? I'm gonna cut to the chase. The only thing I want are the radios, and I want the invoice from the original manufacturer. In this case, it's Nokia. So you give me a Nokia, and they have Nokia right there.
Right.
They have Nokia letterheads.
Yeah.
They have it on construction stuff. I want the Nokia letterhead showing the different radios, the models. I want it to show the cost. It can show the unit volume discount, whatever, but that's what we want.
Is that in the documents that C-Spire has produced?
No.
They provide an
The
internal systems.
the radios make up about 60% of the sales.
Has that been requested?
Yeah, oh yeah, we've asked before.
Yeah.
And this, but to their credit, really, it isn't a matter that their numbers are incredibly low. We just are looking at the inconsistencies, and there may not be enough of that equipment reported on each individual site in order to make up the total cost. The issue that we ran into on these site visits, and I'd like to clarify, the reason that we cut off the visits were, the reality is that we found a great deal of disparity between what was on the rendition and what we found when we did our engineering inventory of the site, okay? And so the sites,
Let me
yes,
make sure I understand what you're saying. Is
Right.
that what you're saying is, what they submitted, the rendition that they submitted,
right,
did not match with what you eyeballed on the site?
correct. And Mr. Shrewsbury is gonna go through quickly, just showing you what we saw in the photos and then what we pick up. So far as this comment about we get stuff from the internet, the reality is that yes, there was a point in time where when we started this, that we would walk into a hearing like this with a stack of catalogs about that high, and we just take them and enter them into evidence, okay? But nobody does that anymore, In fact, I would say C-Spire, probably even as attorneys, as people working in the tax department, probably a vast amount of their information, virtually all of it is online. That's just the reality. So making a disparaging comment about getting it off the internet. The reality is what we're doing is we're going to major suppliers that have published costs that are available to us, and then we're utilizing those prices. One of the interesting things about that
The
is.
only reason you're doing that is because they haven't produced the invoice for that particular piece of equipment.
Correct. Or,
Or
so,
if they undervaluing it, would that be helpful? You go into a manufacturer and it's a particular company that we're dealing with would be undervaluing that equipment, so you have some comparison.
well, right, what we're showing is an example, we showed $22,000 on a radio that, a 4-port, remote radio head, we utilize that $22,000 price. And then we're looking for some parallels with that. Now, you know, to their credit, C Spire reports numbers between like $14,000 and $17,000, $18,000 on the radios. And that really isn't bad. It's not horrible. And we know that there are discounts in place, but we don't know where the discrepancies are. So there are two issues. One are the differences between the prices. The second one is just the alignment. If inventory doesn't match up with what we're picking up out there on site. And I believe Joseph and Chris, both as engineers, they came together and they pretty much came to agreement about what he was seeing and how he had categorized it and so forth. And it was an incredibly helpful exercise, incredibly helpful. So again, thanks to them for doing that. But again, their asset inventories just don't line up. In some cases, they're right up. Some cases, they may even be, you had a couple sites that they were a little bit higher, right?
Yeah,
Chris?
we can, I'll try to get this where anyone can understand it maybe.
Can you get it bigger?
Get
Yeah, get it really nice and big.
We're getting there. So the thing that we want to concentrate on is the radios. Remember I said these are the radios. So the radios make up about 60% of the cell site. The antenna, if you add the antennas to it, you're looking at about 70% of the cell site. So I'm not worried about a 12-cent zip tie. I'm worried about 70% of the cell site. So I don't need access to the cell site necessarily because all the radios and antennas I can see from the ground. I can take photos. And as far as the model numbers, there's only 2 manufacturers that they're using today, Nokia and Ericsson. And these folks happen to use Nokia. I can pretty much find them. I can go on the internet. But what we really want to do is, with C Spire in particular, like you said, the radio costs aren't too bad. I can show you that. The FCC, in June of 2021, did a large project where they were required to come up, and they went to the OEMs of the industry, of everything, and they came up with prices or costs to replace everything at a cell site due to the Huawei issue that they had, where they had to replace all the equipment.
China.
And
It was China made.
And so the radios that we're talking about here, there's only 3 flavors. One of them has 2 ports, one has 4 ports, and one has 8 ports. So the FCC, and I can show you the document, said the 4 ports, or the 2 ports are like $14,000 and something. The 4 ports are about $22,000 something, depending on if it's TDD or FDD. And then the 8 ports are $27,000 or $28,000. Their numbers aren't too bad when it comes to the 4-port, 8-port. I'm okay with that. It's kind of all over the place. I mean, it's 17,000 here, 22,000 here. Some of them are lower than 17. The invoices would tell what that story. I mean, are they buying one at a time sometimes?
Did they produce those invoices?
No, that's my whole point. We wouldn't be here if they produced the invoices for those radios. I'd be pretty much satisfied. But when you get to the actual cost.
So what did they produce that dealt with it? You said they had some values on the radios. What did they produce on those radios?
I think did they give us the invoices on the radios?
Yeah, you told me.
With the letterhead? I didn't see
No, not with the letterhead. It was supplied out of their internal systems.
Oh, yeah. Just a spreadsheet.
So
Yeah,
it's just
it's their supplier portal, that give them that they're saying that it's within their system.
But what we're asking for is verification. You know, the old adage, you gotta verify.
Trust but verify.
So let's just pull the 12 radios, that's the maximum count. So the 12 radios that they rendered was 375,000 total. They took an exemption of 151 and they ended up minus the tower of 223,000 that they're saying taxable. And our value on that is 566. So 566 to 375 is not really that big of a difference, especially when the average labor cost on a cell site is probably about $100,000, 80,000.
So yours is inclusive of labor.
Mine's inclusive of labor.
Right.
They gave us a lot of labor. Okay. So Another 12, they got $885,000. They took $258,000 in exemption, recorded broadband exemption. We have $1 million, so now we're back to that same ratio, 880 to $1,200,000. Another 12, 270, they took 111, we're at 600. I'm using the same metrics for everybody, you know, unlike the last ones that we play favorites or don't do the guidelines or whatever. I don't even look at their rendition that much. I look at it for dates, that's it, because the different technologies are coming in. Why am I at 800, why am I at 800,000 or 600,000 and they're at 270 with 12 radios? That's the only thing that really drives these cell sites. It's the radios. Everything else, they're gonna have the same antennas, the same routers, the same generators, the same fiber. I mean, you have the, you know, everything's gonna be the same, the BBUs. That's the inconsistency we're talking about. This was last year. I'll just do a quick overview. These 3 cell sites, these are 3 cell sites that we actually went out and did a field visit. The water tower, last year they rendered 469. They took 458,000, exempted 520 to 425 this year. At least $51,000 taxed. For this cell site, this is the West Pier site, has a large equipment, metal equipment platform, probably over $100,000, easy. For the entire site last year, they rendered $41,000. And they took a $28,000 exemption. They changed it this year on the rendition. They now got it at 310. No, they're still taking 298.
Wait, say that again, last year was what?
Last year was $41,000 on their
This year
return,
is,
and they took 28 of that. This year, they bumped it up to 310,000, but now they take almost 300,000. So the difference, the taxable difference didn't change. They just jumped up and they took a bunch of exemptions.
all right.
I'm telling you, the tower, the thing sits on
What
top.
what would cause that price to increase?
You have-
That
there's-
much?
There's nothing in my background that would say it should have fluctuated like that.
Well, either the value's wrong from last year.
Yeah. Something.
Jumped
And this
$300,000.
happens to be the one that, Mr. Cups said it might be a one-off because he didn't get the package. We went and walked this site. We asked for the big book. We didn't
This is
get
the one at the
we didn't
port.
get the big book. Chris, what happened, their value went up?
Yeah.
Yeah,
Their rendition went
so
up.
their new rendition is now 310, So but they they could- take 300 in exemption.
They could have replaced a car or something.
Oh,
So you had plug-in equipment in those shelves. Some of those cars are running $250,000 depending on what service or, different traffic. I came from that world.
You did?
Yes.
Okay.
Central office.
I haven't seen the $200,000 card.
They're
I'm-
out there. They're out
At a
there.
cell site?
Software?
Yeah,
Are you talking about software?
I'm talking about actual plug-in
Just the car.
equipment.
yeah, yeah. So, maybe you need to trade places with. Well, okay, so I beat that to death. Just so everybody knows what we're talking about. This antenna, looks like it's an 8-port. Here's your radios are behind it. And on this side, you got 2, 4, looks like it's 15 on this side. Specific model number, that's what we want. We know it's an AHLOA just by looking at it. It's Nokia. All I want is the invoice on Nokia letterhead, showing the cost.
Those invoices are not in the rendition they provided. So what they did was basically just tell us what they claimed the cost was without providing any proof of it.
That's right.
Without providing any proof of what it.
Correct, yeah, exactly. These are platforms.
Right.
That's out there. You know, they run about 20,000, 25,000, 30,000, something like that. But the one that I was talking about is, trying to figure it out here. Maybe I got it in here. Showing up. There we go. By the way, that's a map of all of those cell sites. And just to give you an idea, every one of these cell sites is a mobile broadband cell site. Every time they build a site, it's a mobile broadband cell site. The new law now states mobile broadband, essentially. It's not applying right now. It started July 1st. But all the equipment's on here that the data goes through is exempt according to the law. I agree. We can get into it a little more specific, and you kind of alluded to it, the capable of language is ridiculous. But anyway, they have no fixed broadband. In other words, they didn't add antennas onto these in order to service a Wi-Fi modem in someone's home. And so when you get to the actual rural areas where 5787-3 talks about, in the preface talks about, you can see because these sites are so far away from each other, they can't service, they can't broadcast or transmit a signal inside of a home and service a Wi-Fi modem because they're too far away from the areas. They would have to get a cluster of sites like they have here, out here, in order to comply, or in order to give you internet. Now back in COVID, we all remember seeing people run down to McDonald's, they all, parking lots full, everybody stealing McDonald's Wi-Fi so they can get their computer to work. That's exactly why they wrote the bill. They wanted to get Wi-Fi inside of homes so that you could get on the internet via your computer. You can't do that with ceasefire out here. You might be able to do it right there at that one place because the antenna's pointing straight there, and I can get on my mobile phone and get on a hotspot, and hopefully inside the house I got enough signal. That's not what the bill was written for. The bill was written for these people that supply fiber, DSL, and cable at the time because fixed broadband on the wireless side didn't exist. So those guys need to run a cable out here, some kind of cable, fiber, put a Wi-Fi in the home, and then they could exempt all the equipment. Well, 2021 rolls around, and the industry actually comes up with a way to compete with the fiber guys, and we call it now fixed wireless broadband, or FWA. They overlay the equipment, antennas and radios, and then they offer a Wi-Fi modem to the customer, and they broadcast on this overlay system, separate system. And they could, always talking about language. The language in the bill, the original bill, never mentioned radios and antennas. I remember I said that's about 70% of the cells. I understand why they want to exempt that, but it doesn't say it in the bill. So they went and changed the bill to this new HB 1644. They explicitly separated mobile and fixed, and I'm glad they did, so everybody understands there's a difference. And then they put a speed recommendation, or a benchmark, or whatever, 35.3 on the mobile side, but they said capable of. Well, when you go into the FCC, I'll pull it up. So, the FCC clearly states for residential broadband, it has to be 120, and the fixed side does say, refer to the FCC. But the mobile side is capable of, which means it's not at the point, it's at the point of service, not at the point of service, it's the point of origination. So the cell site equipment, the radio could, I'm not arguing that it's not capable of 35, I'm arguing that the way the law, the new law states, is capable of just means if you just hung the box up there and not even hooked it up, you're in compliance. If you hook it up, you're still in compliance, because capable of doesn't mean at the computer in your home. So 35 ends up being 10, you're not gonna be a happy customer. So, anyway, you get my point. Go ahead.
I understand what you're saying, like those cell towers out in the rural area.
Correct.
You're saying that the equipment there could possibly service Wi-Fi to those homes, but it cannot. Because the towers are so far apart, and they're not actually providing, or will not be able to provide, based on the location where the towers are now.
Right.
A Wi-Fi to those homes, that area, a certain area.
That's correct.
All right,
Go ahead.
but those towers are where they're claiming that they are exempt.
Well, they're claiming all of it's exempt.
They're all exempt, but they're not actually providing the service, the Wi-Fi service in those areas out where the towers are sparsely located.
C-Spire's not providing any Wi-Fi boxes, okay? They started, interesting enough, they started at the end of January this year. They put out a press release, and I have it here, that they're going to start doing that. They're gonna start the fixed wireless part of the bill. It was 1 week before the bill was introduced and passed. It was all done in like 2 days or 3 days. Coincidence? I don't know. But anyway, they're gonna start putting stuff in here that allows you to put a Wi-Fi in your house and have speeds that are compliant with the FCC, under 20 or whatever it is. The regular base cell sites aren't going to give you those kind of speeds. They're not going to penetrate into your home. And you're not going to have Wi-Fi in there, because they're not going to say you want it, because they know they can't support it. You're not going to get the quality, the guaranteed 24/7 coverage, and so on. But I was scrolling here to show you the port site that we didn't get the information on. There is a picture of that equipment platform. That's a big one. That's the biggest one I've ever seen. That's easily $150,000 platform. That's the one where they went from $41,000 last year to 28. This year, $310,000, took $298,000 exemption. What part of this platform has anything to do with any kind of broadband? Nothing. And that's why I wanted the invoices to show me the cost of the platform, show me the cost of the radios. You know, just take it in good spirit, just give us the information. I have no problem taking.
Were they told that, or they asked for that information?
Well, yeah, there's no communication. I mean, most of them don't even recognize us, so.
I guess the question I'd ask, Mr. Whitney, why would y'all not provide them with the invoice?
Well, a couple of things. First of all, these documents that they were given are full of invoices from Nokia assets. Now, are they on Nokia letterhead? They're not. In those instances, we obviously did not purchase them from Nokia. We purchased them from, I guess, a sister entity or some entity that could have potentially purchased them from Nokia, but we can't go get somebody else's invoice and turn that over. So
But that invoice does identify who you purchased them from.
It does, and it identifies that it is a Nokia asset, and it identifies the price. So, again, we can't create records. We're giving you the records of the invoices that we have that demonstrate from who we purchased it and how much we paid for it.
Chris, did y'all get those?
Well, listen to what he just said. I love these logical fallacies these guys come up with. You know, let's get rid of the pool. He said we might have purchased from a sister company. Well, being in the business, nobody purchases from a sister company unless they have the exact same warranties, the type of support, technical support, everything with these radios they require going forward. Okay, maybe you did, but where's the invoice? Where's the that's not an invoice. Where's the $22,000 radio invoice? Show me.
Yeah.
Where's it at?
Yeah.
Dig it out. Let's see it.
Look, what we have here are supplier portals, is what it's called. And those are invoices. They're showing it's showing exactly where it's coming from. And I'm happy, to hear this conversation, it is frustrating. I've been sitting in the back. I apologize. I'm Sheldon Austin. I don't mean to jump in. I just can't stand it.
Your last
Yeah,
name?
sorry. Excuse me?
What was your last name?
Austin.
Austin.
Sheldon Austin. Look, it does get hard sometimes when I go and sit down with these supplier folks and we produce this is called a supplier portal. It says Nokia has the part and what the price, exactly what was paid. It's a supplier portal because you buy it over the internet, right? So talking about internet, you don't go into a Nokia store and purchase one of these things. You're ordering it from somewhere and you're getting an electronic supplier portal piece of paper. We supply them. It is complicated. I mean, I am not questioning anyone's intelligence, by the way. I said that earlier. That's not the issue. But when we produce all of our records, because here's what I do know, and Joseph can back me up on this. When they buy something, anything over $100, for that matter, the zip strings they're making or ties they're making fun of us for, it goes on our books. We want it on our books.
And is issued to the location.
And
The plan is
let me
producing a
finish.
zip ties invoice is like dumping paper. That's not what they're asking.
Well, I got bigger ones.
If the towers are 60% of the, I'm sorry, not the tower.
No, I can do that too, but so here's my.
Then there ought to be, how many towers you got? 60, how many they got? 54? There ought to be 54 invoices you can
Right.
point us to that shows the cost of it.
And when I heard this where it was going, it was like, I don't have this tech. Someone's gonna have to sit down, we have to go through them, and I'll do that. Like, that's the next step, right? I get to go home and pull every one of, any document I have, it's gonna show me my radios, I got it. I'm also willing to sit down, here, let me tell you the process though, this is important. If we're spending that money on that radio, it's gonna show up on the site. Like, that's our process. If we spend, I think it's $100, is that if we spend money, labor or equipment, we put it on a rendition. Because it goes onto our books, these are our books, right? And it ends up on the rendition. So if it's $100, it's $100, if it's $500, it's $500, if it's $20,000, it's $20,000. And that's where our renditions come from, is this process that we run. Now, they've asked us to go back and get all the invoices, which, by the way, I think Mr. Ladner's reasonable request. It's a little harder than I'd want it to be, as I don't, some things are going through inventory and some things are not. But I can get to that price in my books of what was spent to get that item. I've supplied them, obviously. It took me sitting down with my client to kind of say, this number goes with this and that adds here. And I'm willing to have that conversation. I'm willing to sit down with Ms. Ladner, anyone that wants to sit down with my accounting people to go over that, because I'm confident in my process. And any idea that we're gonna sit here today and start flipping through a book and start pulling out stuff isn't helpful for y'all or me, right? So I'm willing to have that conversation anytime. And I hope there's a resolution there, but we're trying to be open book, and I can produce as much backup quote invoice as I can, Mr. Ladner. There is a truth that there might be a limit to what is shown, right? I might be an inventory of something I've spent $25,000 and has 2,500 different pieces to it. So it's hard to put that back together. If that makes sense, if you buy it in bulk, you gotta pull it out. So there's some of that, there's stuff going through inventory that I have to pull out. But I'm willing to go open my books up and show those connections as best I can. And I'll stand behind our renditions. Joseph is the man who handles these things. He knows he needs to get the renditions right, and he knows his expenses need to go on certain towers, and that's what he does. It's possible that there are mistakes in places. It's possible there's a generator at the wrong place. It's a good example, generators. You buy a generator, it should show up on your rendition for that site. It's possible that ends up on something happened in the process, some worker put it on the wrong site. But it ends up somewhere. And two, hopefully it's on my right site, and if it's not, I need to get it on the right side, and I'll make that change. So we can go through this process, y'all can grant or deny our appeal, but that's where we're going, and eventually I'll get there, whether it's Mr. Holloman in a courtroom, or hopefully it's with you guys, because we're doing everything we can to show up our expenses and where they are exactly.
Okay. I'll try not to feel about it.
Please
I've
don't.
got a return here on the water tower. Right here is a radio, $22,999. Let's go to the next, this is 2025, that was 2024. Same radio, same sheet, next year, $20,177. Why did the cost And that's supposed to be the original cost and all that stuff. Why did the cost drop? I'm just asking a question.
Because
Why
we
did-
may have had some other kind of project with Nokia, because Nokia doesn't just provide us electronics for wireless network. They also provide us broadband for 100 gig, 400 gig.
No, I
So,
understand.
you know, those cards you were talking about, that were a couple $100,000 a piece, we buy a lot of those.
As
So-
for the cell site.
No, we buy them for all of the locations that may serve that cell site.
Exactly, that's a switch.
But my
Okay.
point is, you're not taking into account that our bulk pricing
Mhm.
is also including the other fiber.
And we're just looking for the invoice on the bulk price. Okay, we just want the invoice. But I think here on the rendition, why in the world, I know you're not passionate tech, why would a number, a different number, 20,000 show up on the same rendition only a year later that was 22? Now, I like these numbers, probably the best in the industry. I just want the invoices. I'm not gonna share them. Just like the previous folks said, we play fast and loose with invoices. I don't play fast and loose. Here's what I say. Dish is the only one that have been honest with us, giving us what we asked for. That's it. I didn't say how much they were. I didn't say anything about them. He hasn't either. So that's not fast and loose. You know, all of these fallacies, you know, that's fine. You guys can play that game, but I'm gonna play the factual game. Okay? Next.
Chris, if I may interrupt you just a minute.
Go ahead.
Asking for invoices and everything. Is there any proprietary information on those invoices that you would have concern about leaking out or anything of that nature?
Of course. But I mean, in other cases, I've tried to enter into confidentiality agreements and things of that nature, but certainly the cost and structure of what we purchase and put up there is proprietary information.
All right, Tim, in reference, since they're our agent, they're not actual employees of the county. Is there any legal bounds on that they're releasing any information that could be proprietary or anything of that nature?
There can be limits placed on an expert that you retain.
Is that y'all's concern?
Truthfully,
In referencing invoices?
no, truthfully, if I don't have a confidentiality order in this case specifically, I would want one, and I would trust them to keep it confidential. We have not hit behind, not hit.
That's not what.
That
I
hasn't
know
been
what
the
you're
driving
saying.
force.
That's not the reason why.
My driving
yeah.
force is to get the right number.
Right.
How do y'all issue work authorization? Is that engineered step, step one, step two install this?
Yeah, so like, it depends on the specific entity doing the work. Like, for instance, if it's someone internally, then we have a whole different web portal, basically. So we issue the equipment, we have an internal process that we follow. If it's an external,
But that should be issued to an engineer job for capital.
yeah, an OSP project or a site ID.
Or
that-
maintenance,
Correct.
change out.
Right,
I
right.
mean, so, I mean, when I was with AT&T, we had to cut cable. We had a system. I mean, if paper towel come off the truck, we bill for a paper towel.
That's how we
bill
work.
for the zoggers, the cover for it. I mean, that data should be
Right, like
easily captured.
tape,
With
zip ties,
zip ties.
nuts and bolts.
I mean, we bill for everything on a cut cable.
One thing I wanted to bring to you guys' attention, because I didn't bring this up in the other couple of weeks ago. This is an SEC document that just came out. It's for the broadband. Somebody mentioned there is a broadband definition. This is the broadband definition right here. FCC just brought this out last year, and I don't know if I can get this. Yeah, okay. So they came out March 14th. The FCC increases the broadband speed benchmark. Pretty self-explanatory. What this is talking about is high speed into people's households, American households. And it says the speed of the fixed broadband download speed will be 100 megabits per second and an upload speed of 20. That's four-fold increase from what the old 2015 benchmark was, which was 25.3. That's what we have always argued, that if you want to talk speed, then that was the speed, and as of last year, this is the new speed of what broadband is, what true broadband is. They also go on to say that standards now used in multiple federal and state programs, such as BEAD, which is one of the federal grant programs, consumer usage patterns, and what is actually available. That's key. That's what's on my computer. If I was to put a meter or something on there, I'd have 100 or better, okay? Not capable of 35 or whatever. Actual available from and marketed by internet service providers. Now, really, the only way to do that is through fiber, DSL, and cable.
So that's your argument. That's your argument for denying the broadband exemption,
Part of the argument.
part of the argument. That they're
To me, the speed is a red herring. I mean, honestly, it's because they wrote the bill, capable of. What good is capable of?
Yeah.
You killed the bill, you made it invalid when you say capable of, why even pass it?
Well, the bill is the bill.
I know, but I'm just saying technically it's ridiculous, you know?
The bill is the bill.
Okay. But I just wanted to bring that 35 read is what the mobile guys say they are capable of. And I don't think anybody cares in this room of what the mobile broadband can do. I was a design engineer. I know I designed mobile broadband sites, what we call them today. It was designed for people with a phone or device that they were mobile. When they were mobile, going down the road, hand off from cell site to cell site. You know, we all been there. We're trying to get directions, whatever, between cell sites that sits there in buffers. We got low bars. It was built for that. It was built to keep your call up so you didn't drop. That's it. No more. Nothing fancy. Just get from one point to the next. Fixed wireless broadband, which is new to this industry, came out in 2021. All those overlay antennas and stuff. Whole different animal. Now you're guaranteeing somebody a service. You're guaranteeing that you're going to provide 100 megabits download and 3 megabits upload into your home to the Wi-Fi 24/7 quality signal. You're competing with the fiber people that's been out there doing this for 20 years. Whole different story. As far as exemptions are concerned, I think they should, if they follow through and they start putting these overlay fixed broadband assets out there, I think they should get an exemption. Whether it's in a rural area, I don't know. I'm just going by what the way you feel that the old bills, 2057, 87, 57, 3, and 7 were written. They weren't written for this industry. This industry somewhere along the line picked it up and started running with it because of their cell sites. These folks started in 2015 in this county. The other carrier started in 2010, 2012. Another carrier in 2016. 10, 12, 15 years after the bill was passed, all of a sudden we're starting to take, why? That's a lot of questions that need to be answered. Who gave permission? Who gave the authority? Oh, we should go ahead and exempt this stuff. Was an engineer or tech involved? I don't think so. And there's a whole bunch of questions that need to be answered, and I think a lot of that's going to be answered during the court hearings. So I'll wrap it up here. I mean, I could stand up here for 10 hours and talk to you about this. But the bottom line is, we're just asking for invoices. As far as the exemptions, we'll deal with that another day. That's all I can say.
Okay. Thank you. All right, Tim, basically, what you said earlier, that if we were to deny the appeal, discussions can continue and it can be adjusted.
Yes, there can be a.
Because they're willing to talk
Agreed
to y'all all, I think. So, if that's the case, I'm prepared to make a motion to deny the appeal, as long as.
Second.
Okay, any further discussion on that?
Let me say one thing, is there any chance that y'all reach an agreement before Monday? No? Because the only thing bad about the appeals, they have to put up a bond.
Yeah.
I mean, it can be resolved on to the issue about the exemption
Well,
is, to me, something that.
Our
courts will have
position
to
is that
address.
they don't, as of now, don't qualify for the exemption or can't meet it,
I
so,
think that's the question, deny the appeal, and
Yeah.
we'll sort it out in court.
so that's what my motion, Rebecca.
Okay, all in favor of the motion, say aye. All opposed,
Aye.
motion carries.
Thank you very much.
Appreciate it, thank y'all.
Please, Sheldon.
Call me back at 1, okay, when the next one
I
starts.
think it's gonna be 2:15.
Oh, 2:15,
I
Ken?
think we moved it, did you move it?
Did he move it up?
Can we weren't able to get them to come early?
They have not responded.
The next one's at 2:15.
Okay. Thanks, y'all.
Thank
Okay.
you.